If you die without a will in Montana, they say you die intestate, and then you fall into what they refer to as intestacy laws. Now these are very old laws. I would say they date back to the Middle Ages, and it's really it is really the rule of blood. And so it is your closest blood relatives will be your heirs under Montana law. That starts with your spouse, but if your spouse does not survive you, then it goes to your children. If you have no children, or if your children do not survive you, it would try to go back up the chain to your parents, and then to your siblings. It would also look for your aunts and uncles, or even your cousins. Once it finds a category of people that could inherit, in this case, well, let's say the children, it treats every heir in that group equally. And so regardless of whether you wanted them to be equal or not, or whether it's even in their benefit to be treated equally, it's going to treat them equally. The biggest problem we see with that is if you have one person in that pool who is a person who receives a lot of government benefits, that person could lose those government benefits for many, many years by just inheriting a lot of money in their own name. In those situations, we often utilize those special needs trusts. We would have to get court's permission to set up the trust and to distribute the assets the child would otherwise inherit into that trust, just so they could preserve their, again, government program benefits and not have to reapply. And anyone who's applied for those benefits knows how long it takes, and to have to reapply later is a much more painful process.